All right, welcome students. Welcome back to the video lectures. And this particular video lectures, we're continuing in our torts discussion. And remember that a tort is a civil wrong. A tort action is done by one party against another party in a civil setting. So this is not a prosecutor for activities that are criminal in nature. This is a civil actions other than contracts, which we call torts. And really, when we file these torts, remember we talked about last time the intentional torts and damages that result. Now we're moving away from intentional torts and into this discussion of negligence. And so remember, in intentional torts, we had to prove intent with a corresponding act, or an act with intent associated with it. Here in negligence, we throw out intent. There is no intent. All of those intentional torts that we discussed perhaps could also be a negligence claim if we're unable to show that the defendant acted with the requisite intent as it relates to those intentional torts. And so then what we might be left with is proving this concept of negligence. And when you think about negligence, we use the term in everyday English, right? We say, oh, that seems negligent or something. And really when we use that phrase, what are we trying to say? We're trying to say that it feels like that conduct fell below some standard, right? It was negligent. It didn't rise to the level or the standard that typically would be set forth for that action. You're negligent in your conduct. You're negligent in the way you treat another person or something like that, right? We use that in everyday language. So the lawsuit of negligence, and remember, this is a cause of action. Just like a assault or a battery or intentional infliction of emotional distress, this concept of negligence forms the basis for a lawsuit that a plaintiff could recover damages if they can prove the elements of this tort of negligence. And so just like the common usage of the term, really negligence is just that. In summary, it occurs when someone falls below a certain standard of care in their actions or conduct, and because of that falling below that requisite standard of care, that reasonable person standard, they cause injury to another person or their property. That is the tort of negligence. So you can see here in the outline again, and for these discussions, I'm just pulling up the outlines that I have posted online for you in Canvas, and I'm just kind of discussing the material as we scroll through the outline. So when someone suffers injury because of another's failure to fulfill the required duty or standard of care that we're talking about, this is called negligence. So let's look at the elements of this cause of action, negligence. So to succeed, as in any lawsuit, the plaintiff must prove the elements necessary to satisfy the legal action that they're claiming, right? Or using, or bringing forth in their lawsuit. And so in order to prove negligence, you must prove four elements: duty, breach, causation, and damage. These four elements you must prove, and they must be proven by a preponderance of the evidence. And we talked a little bit in a couple lectures ago about the difference between the burden of proof between a civil case and a criminal case. And recall that in a civil case like this one, a tort action, the burden of proof on the plaintiff must prove the cause of action, must prove their case before they can win. But the burden of proof that they have is by a preponderance of the evidence. And sometimes we define that as tilting the scale in the plaintiff's favor. So if we were to put a scale and we had evidence piling up on it on either side of the scale, and the plaintiff is able to tilt that in their favor, then they have proved their case by a preponderance of the evidence. Just tilting it, just enough evidence to tilt it in their favor, right? 51%, let's call it, but just over 50%. Just enough evidential weight to tilt that scale in their favor. That's a preponderance of the evidence. That's opposed to criminal cases, which we talk about the burden of proof being beyond a reasonable doubt. That burden of proof is much higher, and we will talk about that and define that when we go into criminal law in Chapter 7 next, or the next discussion of criminal law. Sometimes it's, depending on the book I'm using, it might not be Chapter 7. So Just know that we will talk about that in criminal law section. So in order to fulfill this or to prove this case of negligence, one must prove duty, breach, causation, and damages. So let's take a look at these elements. The defendant owed a duty of care to the plaintiff. The defendant breached that duty. That breach caused the defendant's injuries, and damages were sustained. They had legally recognizable injury. So central to this tort of negligence is the concept of duty of care. And so really we operate in society under this kind of basic principle that all of us in society owe each other a duty of care, to act in a way that doesn't infringe upon another's interests or ability to live and act in their way. So we act and interact together in society, and oftentimes, we're fine, right? But sometimes we collide, literally and figuratively. And so then we have to step back and say, well, was the collision, for example, a car accident, caused from a lack of the defendant's following or underlying this basic principle of duty that we owe to other people in society as we interact with them, right? So this would be this first element, this first kind of conceptual hurdle to cross, is to say, okay, what is the duty of care in that particular situation? And did the defendant violate their duty of care? So what is generally this duty that we are required to act under as we interact with each other in society? What does the law call this duty of care? And so what we call it is the reasonably prudent person standard, or as the outline calls it, the reasonable person standard. I like to add in prudent, but it's the same thing, right? This idea that we would act reasonably under the circumstances. And really what this question is leading to is that we would kind of try to kind of understand what a so-called reasonably prudent person would do. They would be careful, conscientious, even-tempered, honest, right? All of these kind of adjectives that we go to describe what we might call reasonable. This is an objective standard. I like to term objective standard as if we're looking down on the factual scenario from sometimes I'll say a 30,000-foot view, right? We're looking down on it and we're analyzing the actions of the individuals, and we're saying, was that reasonable? Was that conduct reasonable under the circumstances? Would a reasonably prudent person do the same thing, or would they act differently? Did the defendant act differently than a reasonably prudent person would under those same or similar circumstances? So that is the question that we must ask, and we must kind of define what that reasonably prudent person standard is in element 1. So then we move to this idea of breach. So did the defendant breach that duty? So as you can see here, understanding how to define it, we can also then start to look at what would be a breach. Excuse me. So once we've defined what the duty of care is, and we understand the standard that we operate under, this reasonably prudent person standard, when we look at the conduct, just as I was saying before, is we can start to say, hey, that action by the defendant doesn't adhere to this duty that we believe exists under this circumstances. They didn't behave reasonably under the circumstances. They were not a reasonably prudent person. Therefore, they have breached their duty. We then move down. Here's in the outline, you can kind of look at some examples of breach as it relates to the duty of landowners and then the duty of professionals. Just quick note here on duty of professionals. We're talking about physicians, dentists, professionals, architects, engineers, accountants, lawyers. And they're really, it's the same standard. We just add a twist. We say of a person that possesses that same knowledge, skill, and training. So we must act as a reasonably prudent person with that superior knowledge, right? Understanding that the training of a physician, of an architect, a dentist, an engineer, an accountant would apply. Not just the reasonably prudent person standard of anyone in society, but obviously of a professional in the same or similar profession. And so that's the standard of care for professionals. We often call negligence claims based on a lack of, on a breach of this standard for professionals, malpractice, right? You've heard that term before, about this concept of malpractice, and that's what we're talking about when professionals don't adhere to their required standard of care. We call it malpractice. So let's move down to this third element. So we have duty and breach. We talked about duty, and now we talked about breach, which is just simply kind of not adhering to the standard of care, right? They breach the duty that we've identified should have existed under the reasonably prudent person standard. So then we have to go to causation, and so the courts ask two questions as it relates to causation. The first, what we call causation in fact, and then the second, what we call legal cause or proximate cause. And causation in fact is kind of an easier question to answer. And we say, did the injury occur because of the defendant's acts, or would it have occurred anyway? If the injury would have occurred without the defendant's acts, then there's no causation in fact, right? Because then there's not a direct link between the act and the injury. So really in causation in fact, we're saying it didn't in fact the act of the defendant caused the injury. In other words, if the plaintiff would have been injured even if the defendant had not acted, then there's no causation in fact. Did the injury occur because the defendant's act? Yes. Then there's causation in fact. If the injury would have occurred whether the defendant would have acted, then no, right? There's no causation in fact. You don't have to step down or look at the second prong of causation, which is proximate cause. Typically, causation in fact is very clear, right? The defendant acts, injury results from the act, that's causation in fact. A kind of a more, I guess, difficult concept to understand is proximate cause. I don't know if understanding it is difficult, but a little bit more of an analysis point occurs when we talk about proximate cause or legal causation. And proximate cause is defined as this connection between the injury and the act. There must be a strong connection between the injury and the act to impose liability, legal liability. And so when the connection between the act and the injury is strong enough to impose liability, it is said to have proximate cause as well as causation in fact. So what does it mean to have a strong connection between the act and the injury? Well, the question that we ask under proximate cause is, was the injury foreseeable from the act of the defendant? So what we're really asking is it the type of injury that would have been foreseeable based on the act of the defendant? A foreseeable risk of injury that is the type that would stem or flow from the defendant's actions or conduct. Foreseeability. Maybe another way of saying this is just how it's written here, is this kind of concept that the law is saying under proximate cause that it wouldn't be fair or it would be unfair to impose liability on a defendant unless the defendant's actions created a foreseeable risk of injury. Great. I like that definition as in the outline here, but also just conceptually follow me here when we're saying, okay, well, the proximate cause test really says, is the injury of the type that would be foreseeable from the conduct of the defendant? Is the injury of the type that would be foreseeable from the conduct of the defendant? And there's a landmark case, and it's in your textbook, and you can look it up online as well, which is called Palsgraf versus Long Island Railroad. And, it's an interesting case, so I want to take a minute just to talk about this Palsgraf case, because it's 1928, and we still post it and read about it and understand the holding of Palsgraf, because it really kind of clearly enunciated this legal causation or proximate cause. And what Paul's graphs, the facts are simple. Paul's graph, well, not simple, but here's the facts of Paul's graph, essentially in summary. Paul's graph is on a train platform, and she's at one end of the platform. And all the way at the other end of this long train platform is a gentleman holding a gray box container package. And he's running to get on the train. As the train starts to leave the station, some of the employees from the railroad try to help him on. There's an employee on the train and two, I think, at the bottom on the platform itself. And as they're trying to help the gentleman who's running for the train, he stumbles and the package falls. Well, the package is fireworks, explosive fireworks, and they ignite and they explode and they cause a rattling and a shaking of the platform. And as it rattles the platform, Mrs. Paul's graph, who's on the way far end of the platform, is injured when some scales fall due to the explosion. They fall and they land on Mrs. Paul's graph, and she is injured. So Mrs. Paul's graph sues the Long Island Railroad, and she asserts negligence, right? So if we go through this, we say, all right, well, let's talk about this. Duty, breach, causation, and damage, the elements of the negligence claim. And so the court kind of goes through this. Defendant owed a duty of care to the plaintiff. Yes. Was it reasonable for the conduct of the defendants to help this gentleman onto a moving train? There's some discussion about this, but ultimately they said this was really not very safe, although they didn't know what was in the package. Is it really reasonable to try to throw someone or help someone jump onto a moving train? Probably not likely. So the court was like, this is, although they didn't know what was in the box, this isn't kind of standard operating procedures. This probably shouldn't be done. So yes, it was probably a breach of the duty of care as it relates to safety and other things as it relates to climbing onto moving trains, right? Or departing trains from the station. But where the case really stalled was in causation. And the Paul's graph court said that although the injury was the direct cause, the causation in fact of explosion in the package was the direct cause, or the causation in fact of Paul's graph's injuries, they said that this was not a foreseeable injury, that the risk of injury wasn't foreseeable from the conduct of the defendants. In other words, the railroad employees couldn't have foreseen the risk associated with the type of act that they were undertaking, which was to help this individual onto a moving train. Now, let's pause for a second. Do you agree? Do you not agree? Because what does this mean? So proximate cause I like to look at as a limiting liability factor. So really what we're saying here when we analyze proximate causes or causation in general is first, causation in fact, which is more direct. Then second is this proximate cause with this foreseeability analysis. Typically what we see is that this is where legal causation fails. Causation fails because legal causation, foreseeability, says no, this wasn't foreseeable. The injury wasn't foreseeable from the act, therefore we're cutting off liability. So when the court said this was not foreseeable, Paul's graph lost her negligence claim against the railroad. In other words, the railroad wasn't liable for Paul's graph's injuries. Okay, so a lot of students will say, well, that seems, horrible. Poor Mrs. Paul's graph. And I kind of agree. So if we step back and say, why would we want this? Why would we even want this? Shouldn't it just be causation in fact? Great question. Why have this foreseeability test? Really, it limits liability for individuals and corporations for that matter, companies like Long Island Railroad. And I think really what the kind of idea behind this is that should we really impose liability for this dramatic events that are not foreseeable from acts, right? So then, because what we're really saying here is you didn't do it with intent. There was no intent to cause this harm. It was negligent. You kind of fell below a standard of care, but it wasn't an intentional act. So then we want to say, well, would you be liable for all the damages that stemmed and flowed from this negligence? Should we hold you liable for all those things, or should we limit that liability and say, no, you're only liable for those things that are foreseeable from the act that you've done? So maybe that helps. I don't know, but this is still good law today. So in order to prove a negligence claim, you must prove both causation in fact and legal causation. And then we flow into the last element of the negligence cause of action, which is injury. So you must suffer some legally recognizable injury to recover damages. And we talked about damages before, so you can kind of refer back to my damage discussion in my previous lecture. But safe to say, if there's no damages, then you would not file a claim, because why would you spend the time and effort to file a claim without some kind of recognizable injury? So if there's nothing to compensate, then there's no tort. Some kind of interesting notes, and I like to draw these out, or at least in a lecture and in class I'll talk about this, is some kind of interesting areas of law in California. So one is, because a lot of times students will ask, well, what about this? I've heard of this Good Samaritan statutes and these liabilities for people getting drunk in establishments, and who's liable, which are sometimes referred as to dram shop acts. And so first is a Good Samaritan statute. And so most states now have what are called Good Samaritan statutes. And under these statutes, someone who's aided voluntarily by another can't turn around and sue them for negligence if the aid that's been given to the individual causes them harm, or the way in which they aided the individual was negligent, or assertion of negligence, falling below some standard of care. Now, so if you see an accident or something, and you run to help them, to pull them out of the car, and the cars are all mangled on an interstate or something, and you grab the individual and you pull them out, and by doing so they have a broken back or neck, and by moving them there could be an allegation that movement caused further injury to the individual, and they should not have been moved at that time, but the car was smoking and you thought it was going to explode, so you pulled them out thinking that you're going to save their life. But then some doctor is going to testify that movement and pulling of the individual out of the car without bracing their neck or back caused greater injury and was negligent. This is what Good Samaritan statutes are designed to protect, this good faith rendering of emergency medical or care at the scene of an emergency, right? So this, I gave you California's Health and Safety Code 1799.102, which says essentially what I'm telling you is that you're not going to be liable if you render aid to a person in good faith, that they can't turn around and sue you for negligence. I think that, in this, the legislature says here it's to encourage other individuals to volunteer without compensation to assist others in emergency settings, right? That's the intent, is to give this good faith actor a protection under law, California Code, to protect those actors who go in good faith and try to help people. Now, right? So I think we like that as a society, right? We want people to help. The only exception to this, as you can see in subsection 2, is that you could be liable. So it says, no person who in good faith and not for compensation renders emergency medical or non-medical care or assistance at the scene of an emergency shall be liable for civil damages resulting from any act or omission other than an act or omission constituting gross negligence or willful or wanton misconduct. So this is kind of an important section of this particular law, where it's really talking here about, okay, there's an exception here if you're grossly negligent, right? You're no longer doing what would seem reasonable under the circumstances. Now you're doing your negligence goes beyond this falling below some reasonably prudent person standard, but it's just so far beyond the realm of rational thought that you've committed this gross negligence, acting in a willful or wanton disregard for the value of this particular situation and this intentional misconduct almost. So this gross negligence and willful or wanton misconduct is an exception. You know, I don't know if we could come up with examples, perhaps, but in my, hypothetical car accident, if we could constitute gross negligence, I don't know, maybe you pull them from the car and you see that their leg is broken, and so you undertake and you've called an ambulance and you know that they're on the way, and you undertake this idea of resetting the bone for the individual while you wait for the ambulance, and you do it incorrectly, and you tear ligaments or you break another bone by doing it or something like that. The person complains of a headache from the accident, and you go and try to relieve pressure on the brain by some medical procedure that you watched on Netflix, right? That would be misconduct. Gross negligence, willful misconduct. Those things would not be protected. Okay, lastly, let's talk about this, or not lastly, but let's move to this dram shop. So many states have also passed these dram shop acts under which these laws hold bar owners or bartenders liable for injuries caused by persons who become intoxicated while drinking at the bar. And so the bartender, and then through other laws like and through other concepts like vicarious liability and respondeat superior, which are theories that make the entity, the bar, liable for the actions of the employees, right? So that's vicarious liability. And so these dram shops would say, oh, the bartender's liable, but then also the owner might be held liable because they're liable for the acts of their employees that when they're acting in their position as an employee. Some states even extend these dram shop acts to impose liability on social hosts. So if you invite people over to your house and they drink too much and they go hurt someone or hurt themselves, they could sue you. California says, recognizes this concept of dram shop and says, but limits it. They have this statute under California Business and Professions Code and California Civil Code. And when you read both of these, really the intent of the legislator was to kind of refute this concept of dram shop and then impose liability on certain under certain circumstances. So you can see here under the Business and Professions Code, every person who sells, furnishes, gives, or causes to be sold alcoholic beverages to any habitual or common drunkard or to any obviously intoxicated person is guilty of a misdemeanor. But then it goes on to say so you could be guilty of a misdemeanor, but no person who does this shall be civilly liable to the injured persons or the estate of the persons for injuries inflicted on that person as a result of the intoxication. Further, in California Civil Code 1714, the law goes on to further say in this section here that injuries incurred as a result of furnishing alcoholic beverages to an intoxicated person is not the proximate cause of injuries resulting from intoxication, but rather the consumption of alcoholic beverages is the proximate cause of injuries inflicted upon another by an intoxicated person. So a little bit contradictory, right? Misdemeanor, if you sell to a drunk person and know they're drunk, could be liable for a misdemeanor. But then this section and the Civil Code section seems to say, yeah, you could be liable for a misdemeanor for serving an obviously intoxicated individual, but you're not going to be liable for civil damages for an individual being injured by that intoxicated person. The only exception to this is found here later in the Civil Code section, which says if you are liable for serving alcoholic beverages to a minor person under 21 years of age. So this is an exception that if a guardian or anyone other furnishes beverages to a person under the age of 21, then this may be found as proximate cause resulting in injuries or death. This claim could move forward. So this is an exception saying, hey, you know what? We protect you if you're serving 21 or over, because really we're saying that the proximate cause isn't you serving, it's them becoming drunk, that each person can freely say no to alcohol and should know when to stop, but they don't. But when it comes to a minor under the age of 21, the exception is removed and you could be held liable for civil damages as a result of that drunkenness and your involvement in that, causing that drunkenness by serving that minor alcohol. Okay, so let's quickly look at, this is again going a little bit farther. All of my lectures here seem to take longer than I think. I'm trying to go 15-20 minutes. They usually go 30 to 40. But let's quickly wrap up with some of these defenses to negligence. And so when we talk about defenses, we're talking about assertions by the defendants that are a defense saying that, hey, if we can prove this, then we're not going to be liable, or we're able to show perhaps that the plaintiff is liable or has some partial liability claim against the plaintiff, or we're not liable at all due to some defense that we're going to assert. So the first kind of defense to negligence is this concept of assumption of the risk. And really what assumption of the risk is saying is that the plaintiff is assumed the risk by voluntarily entering into this situation and knew the risks associated with the situation. And because they voluntarily entered into this risky situation, knowing the risk involved, they should not be allowed to recover from the defendant. This is the defense of assumption of the risk, right? Knowledge of the risk and voluntarily assumption of the risk. You can see the spotlight case, the Seattle Mariners. This is an interesting case. Quickly, the facts: a woman goes to the baseball game. She's not paying attention, and I can't remember if it was the ball or a bat comes off the field. It's in pregame warm-ups, by the way, too. It wasn't even during the game. She's hit in the face and she's severely injured. She sues the Seattle Mariners and alleges negligence, that they should have protected her. Duty, breach, causation, and damage. They had a duty to protect her. They breached that damage. It was the causation in fact, and it was foreseeable that she could have been injured in that way. And she was injured, she suffered damages, and she tried to go forward with a negligence claim. On its face, you might say, that's a rock-solid case. She's going to win. Well, the Mariners came back and said, hey, you know what? No. She assumed the risk, right? She had knowledge. What is the knowledge of the risk? Well, what's the risk associated with attending a live sporting event? Well, if you've seen any kind of baseball games, been to any sporting event, occasionally accoutrement from the game itself will come on out of the playing field and into the stands. And so they really argued that this was knowledgeable, that she had knowledge on this, that people would know that this might happen. And this is the risk associated with attending the event. And by attending the event, she voluntarily assumed the risk. And the court agreed with that assertion. And so she lost. The court said she assumed the risk. Assumption of the risk is a complete bar to recovery by the plaintiff. And so she was unable to recover for those damages due to this defense to negligence. Superseding cause is an argument that's made that says, hey, an unforeseeable intervening event may break the connection between the wrongful act and injury by another. This is a situation where some superseding or intervening event happens, and therefore that event is what's caused the injury, not the defendant's actual act, because someone else intervened and caused that injury to result, as opposed to the individual actor, which is called superseding cause. Finally, we have what we call contributory negligence. This is is where individuals don't exercise their own reasonable degree of care in looking out for themselves. And because of that, the defendant will say, hey, I might have some negligence here. I might have fallen below some duty of care, but so did they also fall below a duty of care, because they weren't even acting reasonably for themselves under an analysis of reasonable and prudent person standard for the plaintiff. They fell below the reasonably prudent person standard. I may have as well, but they definitely fell below the reasonably prudent person standard. So there was some contributory negligence there, and the defendant would ask the court to measure that contributory negligence and then allocate damages accordingly. So maybe we would argue that the plaintiff is contributory negligent up to, say, 40%. And if that's the case, then if there is a damage award, the court would reduce that claim by the plaintiff's fault percentage. Some jurisdictions have pure comparative negligence. And this is what California has, which allows the plaintiff to recover even to the extent of plaintiff's fault is greater than the defendant's. That's called pure comparative negligence. And then other states with just comparative negligence statutes say once the plaintiff can prove, or once the defendant can prove that the defendant, once the defendant can show that the plaintiff is over 50% at fault, contributory negligent, over 50%, it bars recovery for any damages from the defendant. In other words, you would be asserting that the reasonably prudent person standard was applied to the plaintiff, and as we analyze how they acted, they fell below the standard, and they were 50% or more at fault for the injury, and because of that, the defendant does not have to pay. This is in stark contrast to pure comparative negligence, which allows that analysis, but the plaintiff can recover even if they're over 50% at fault for the injury, as long as they can show that the defendant was at fault as well. Take a look at, I'm pushing here 40 minutes, so I'm going to let you kind of take a look at strict liability and product liability on your own. And we will come back to I will come back to these video lectures with next discussion on criminal law. I hope you're enjoying these lectures, and please feel free to email me or inquire about doing a private Zoom session if you want, or attend the posted Zoom lectures for the class as well. Look forward to talking with you all, and have a great day.